Welcome to this week's edition of Debriefing the Law. I am Joel Oster.
I'm Chris Marone.
And Chris, I am very jealous of you. We are here. We're going to talk about March Madness Part 2. It's the Final Four. I am a huge basketball fan, and you are on your way to New Orleans. Chris,
watch your KU Jayhawks take on the Final Four.
You live a blessed life. I cannot believe you're going to probably my favorite city, and then my Jayhawks going to be there in the Final Four. Are you going to try to find a way to get in and watch the Final Four?
I was, but I'm bringing my wife with me because I proposed to my wife 10 years ago in New Orleans. So we're going back for kind of this anniversary trip. So I'm going to see if I can sneak in and if she would still be married to me if I chose our anniversary weekend to go watch some KU Jayhawks.
That would be pushing the boundaries there. True love.
She's a forgiving woman. It could happen.
I did a StubHub search, and I think you can find some tickets in the outer, like right next to the bathroom, for about $500 maybe. I think it was like after expenses, but you can find some tickets for like $19,000 if you want to sit pretty up there in the suites or on the floor. But hey, I am very envious of you down there. You need to check out Cafe Du Monde. They have the best coffee. I know you don't really care for coffee, but they have, I hope I'm pronouncing this right, beignets, which are powdered sugar donuts. They are delicious right there in the French Quarters. That is one of the spots I always go and hang out at because there's usually a jazz player. Now, for listeners who don't normally go to New Orleans, let me just tell you, one time I went to the Cafe Du Monde, and you can sit out there. It's outside cafe.
Yep, it's beautiful.
You're drinking your coffee. You're eating your beignets, and there was a street performer playing his saxophone right in front of me. It was a lot of fun. He looked like some kind of homeless street performer just playing the saxophone, doing a good job. Well, that night, I decided to go to a jazz concert there in the French Quarters. I went to a really nice, it was a much more expensive ticket, right? Everyone there was in suits, that kind of thing.
Oh, of course.
That same sax player was playing lead sax in that concert. So, yeah, when you're out there at the Cafe Du Monde, those are real musicians that you are listening to. So I am so jealous. Now, do you like oysters?
I do. I do.
You've got to do this here. Take your wife to it. It is called Drago's. Have you ever been to Drago's in New Orleans?
I have not.
All right, Google it when you get there. It is advertised. They have on their menu the best morsel of food served anywhere in New Orleans. It's right there in Drago's. It is a grilled oyster on the half shell. It is fabulous. I am so envious of you. If you go there, take a picture of it and send it to me, and then I will violate the 10th commandment by coveting your current situation. But hey,
I can't wait.
We got a lot to talk about today. There's a lot of stuff going on in the world of law and sports. This is March Madness because of our basketball situation, but also because of what's going on there at the Senate. And I want to revisit what we talked about last week involving Judge Ketanji Brown Jackson's Senate confirmation hearings. And so we talked about it a little bit last week, and I think we both agreed it's a circus. I mean, this whole scenario is somewhat fraudulent. It's not real. She's not really there to answer questions. She is there to avoid the knockout punch and making a mistake. She does not want to get Robert Bork, where Robert Bork kind of lashed out at the people asking him questions. That became a spectacle, and then it derailed his confirmation. So that's kind of what these judges seek to do, avoid the knockout punch.
Right.
Well, she had two answers that I want to just focus on here for just a bit. Because at first blush, these answers were just seemed as, oh, that's just trivial. I mean, that's just some kind of gotcha question that was asked by the questioner. It's not really a real question. But I want to actually dig in a little bit deeper because it has been bothering me all week. I can't let it go. So, Chris, I know we're on the opposite ends of the conservative liberal spectrum, but I want to have this discussion.
Yeah.
Two questions here. The first one is her answer when she was asked, can you define what a woman is? She said, I can't because I'm not a biologist.
Right.
Chris, that's been bothering me all week. I just, at first I just kind of dismissed it as being, it's just a circus atmosphere. But the more I'm thinking about it, you are telling me you can't answer, you don't know how to tell the difference between a man and a woman. You can't define what a woman is. I don't know, Chris. Well, what is your take on that?
I don't have an issue with that. She's speaking outside of the fact that she doesn't have expertise in making scientific determinations of sex, and rather not assuming what is going on. What I feel, because it's a circus, what Senator Blackburn was trying to do was she wanted to lock her into saying that there was only two genders, which is false because gender is a social construct. And I don't think Senator Blackburn understands that. She wanted to lock Justice Brown into saying that there's a male and a female, and then she wanted to go on some huge tirade about things that are not even relevant to the proceedings, like every other senator on both sides did.
I get that, but she was asked if she could define what a woman is, and she said, no, I'm not a biologist. Now, this is why it has really gotten to me. I mean, we have kind of lost sight of the forest of the trees. I mean, when you have gender reveal parties, right? Hey, you're pregnant. Is it a boy or a girl? We say, oh, it's a boy or it's a girl. We don't wait 5 years to ask the baby, now a child, what sex that baby wants to be. We look at the genitalia and say, it's a boy or it is a girl. I don't understand why she could not offer that simple definition. Let me put it in a different context. Judges rule on sex discrimination cases all the time. In fact, it's a constitutional violation if you discriminate based upon sexes. You have to understand as a judge the difference between a man and a woman. And whenever you have a sex discrimination case in court, you don't ask for expert testimony on that issue. It's assumed the judge knows how to tell the difference between a man and a woman. Is that changed now? Or are we just to accept her answer as a trite answer, and we're just going to say, oh, that's just a circus. She was just trying to not play along and answer the questions, and we're not going to treat it too seriously? Because I'm having a problem with that.
And I totally get your problem with that, Joel. In Scientific American, they did a series of articles spanning from October of 2018 to up till last year, talking about the oversymptomatic idea of two sexes. Now, for the law, sex discrimination is very clear. If you're discriminated on based on the sex that you identify with. If you are, and it's not like today I feel like I'm a woman and you're discriminating against me. There are factors that go into understanding how you identify as your sex or as your gender, more likely. But there's more to the XY XX chromosome argument that, again, I'm not a biologist, but in reading these stories, and as Justice Jackson had said in there, I wanted to find out more about what's going on. There's a great articles in Scientific American that talk about it that are very I believe Scientific American is non-political. It's just a discussion of biology and what is coming about now that biologists have more equipment and technology to figure it out. And I understand your argument of you're born, we look at your genitalia, we assign male and or female based on reproductive organs. But in the changing world of what we have going on right now, defining for the sake of rights, privileges, you have to look at the individual as an individual. So maybe we are going to be changing into a time where expert testimony is going to be needed to prove that this person who may have been born with male genitalia identifies and should be treated as a female under the law.
Now, I am not willing to go there where I believe you just said that the sex discrimination is based upon what gender you identify with. I don't think that's the basis of our equal protection laws. But nonetheless, I do get that there's a certain movement to push the law in that direction, and maybe this would have been an opportunity to highlight that and have some conversation of, is that where you want to push the law, Judge Jackson? Is that let's have a discussion about that. Instead, she said, I'm not a biologist. I can't offer that distinction. Now, let me give you another context why I have a problem with this. I don't think she was being 100% forthright. I don't know if that's true, or if let me just go ahead and say my piece, and then we can unpack why I have a problem with this. She was also asked by Senator Marsha Blackburn this question. Senator Blackburn said, let me ask you this then. United States versus Virginia. The Supreme Court struck down VMI's male-only admission policy. Writing for the majority, Justice Ginsburg stated, supposed inherent differences are no longer accepted as a ground for race or national origin classifications. Physical differences between men and women, however, are enduring. The two sexes are not fungible. A community made up exclusively of one sex is different from a community composed of both. Do you agree with Justice Ginsburg that there are physical differences between men and women that are enduring? Okay, that was a question about the VMI case. This is a landmark case on women's rights, written by RBG, an icon of the Supreme Court, and Shirley, Ginsburg writing the majority opinion here. That was Ginsburg's main mission in her jurisprudence. Mission is to fight for equality among the sexes. And here Ginsburg said that there are physical differences between men and women that are enduring. So they asked her, okay, well then how do you agree with Justice Ginsburg? This was her response. She said, Senator, respectfully, I am not familiar with that particular quote or case. So it's hard for me to comment as to whether, Chris, I'm struggling with that. That's like her being asked a question about abortion and saying, oh, this whole Roe v. Wade case, I'm not really familiar with that case. Can you tell me a little bit what it is about? Are we to believe that Justice Jackson hadn't actually read VMI?
Oh, 100% she's read VMI. 100%. She's ruled on it.
She just said she wasn't familiar with the case.
Yes, because we're in the middle of a circus, and answering questions from Senator Blackburn is a black hole of nothingness. So as I guess, again, we're playing the political game. And I am not a fan of Senator Blackburn for a multitude of reasons. Okay. But she was trying to have a gotcha moment.
Right.
That's what she was trying to have, is a gotcha moment. Ha, got you. Women are women, men are men. Ha, I'm smarter than you. And Justice Jackson was not playing that game.
Or she wanted to know if she agreed with RBG's statement in the VMI. Again, she is. I think it was applying.
She's not smart enough. Senator Blackburn's not smart enough to have. She was trying to box her in on this idea. That's why all of her questions were about making the delineation. She wanted to box Justice Jackson in so that way she could have a gotcha moment. And I fully believe that she knows the VMI case the same way I fully believe that Amy Coney Barrett knows the First Amendment and what's in it. Fully believe it.
I would agree that she does.
Right. But when Amy Coney Barrett was put on the spot to ask what the rights were in the First Amendment, she fumbled it. So
So your point is that you can have brain farts in the middle of confirmation proceedings, and I will grant you that. That is possible. I am also a public speaker, and I know sometimes you misspeak. And so to blow one answer out of proportion, yes, it might be wrong. It might be isolated by itself, inexcusable. In a broader context, maybe she just misspoke. She's put there on the spot. Maybe she just misspoke. Chris, that actually is a good point on that. I'll give you that one. All right. So again, maybe I will stop having a problem with this issue, but the memes keep coming about how people will say, they'll be asked a simple question. The answer is, can't answer that. I'm not a biologist. I'm not an economist, whatever. And so I'm sure the memes will keep on coming.
You know what? I actually believe that if people started doing that, we would have less fights on Facebook. If people were like, I'm not a constitutional scholar, great, then let's stop having a fight on Facebook, shall we?
Oh, hold on a second right there. Hold on. I got into one of those this last week, and I loved it. Because I shouldn't have done it, but someone made it their opinion. I wanted to respond to it from a legal perspective. So I said, well, this actually is what the Constitution says. And the person says, oh, what, are you a constitutional expert?
As a matter of fact, yes, I am.
Actually, it's my job. I'm a lawyer, not just a normal lawyer. I do constitutional law, and we teach a class around a podcast. Hey, I actually offered, you might want to check out our podcast. We talk about these issues. I have a liberal friend on there as well. So your side will be represented, but nonetheless,
I'm here.
I like that whenever you do engage in some kind of, you're not a lawyer. Well, maybe we are. All right, moving on here now to our next issue. The issue of Clarence Thomas's recusal. All right, let me set the stage here. The issue here is his wife had sent emails to the White House chief of staff concerning the 2020 election. This is all around the January 6th incident. All right.
Right.
So those emails were a part of the documents to be subpoenaed by Congress when Congress was wanting some information about correspondence with the White House regarding the January 6th incident. All right. Should Thomas have recused himself from any court proceeding dealing with the subpoena of those documents? Now, Chris, I am not on this. I did a little bit of research. I cannot say whether or not Thomas knew that those emails or those text messages actually were from his wife. I'm not sure he actually knew that. I know the issue was should they be allowed to subpoena these documents. I'm not sure the court actually had those documents in its possession when they were ruling on it, but nonetheless, the issue is, should Thomas have recused himself from those cases? Before I go any further, Chris, I'll give you a chance to respond.
Yes. And whether or not he knew about it is neither here nor there. I think he could have recused himself because he was too close to the situation, and it has an appearance of non-impartiality. I was talking to a couple of my judge friends here in Arizona. 3 or 4 of them, we get together, we talk about law and all sorts of stuff. It's a great experience. All of them would lose their seat on the bench, lose their job, if they had a political sign in their front yard supporting one party or another.
Okay.
So they are hypersensitive to their position of appearance of and requirement to be impartial in all political dealings.
Right. And there is this ethical rule, and it does apply to judges, that you should recuse yourself from a case if there is an appearance that you cannot be partial in a certain case. However, it's important for our listeners to understand that those same ethical rules do not apply to the Supreme Court. Now, before you get your feathers all up in I don't even know what the right phrase for that is, but nonetheless, before you get all... Okay, good. Before you get too upset over that, you mean the judges, Supreme Court judges don't have to be ethical? No, that's not it. No. They don't have the same ethical rules.
Correct.
And here is why. Below, so we're talking about district court judges, or we're talking about magistrate judges, or we're talking about appellate court judges. If they recuse themselves, another judge just steps in. So you don't actually lose that spot there. Another Article 3 judge or qualified jurist will replace that particular judge who recused him or herself. But the Supreme Court is a court of 9. So when one judge recuses him or herself, there is no replacement. And that could drastically change the outcome of these decisions. So that's why the Supreme Court has said we're not going to be bound by the same ethical recusal rules because the consequences are so much more dire at the Supreme Court level. Also, there is this thought that judges who have spouses, they're professionals, and they will not let their spouse's views impact what they do. And so the issue then here is, well, what did Clarence Thomas know about what his wife was doing? Just because the wife was an advocate of these kinds of conservative causes does not mean that she shared that with Clarence Thomas, that Clarence Thomas knew what she was doing. I mean, I'm not sure he actually read her text messages, on her phone or her emails. So did she send these out to the White House without Clarence knowing it? I would assume that that's plausible. I would think if she were, concerned about her husband, she would not have run to buy him first, knowing that he then could not sit on those cases. So there's a lot that we don't know yet. So maybe the other thought is, well, let's subpoena her then and ask her, what did she tell her husband? I don't know. Any thoughts?
How bad would that look? That they subpoena her, because right now we're in a democratically controlled Congress, right? And the Democrats are itching to do anything to smear Republicans, like Republicans itch to do anything Democrats, right? They subpoena her, and then they're going to do it. And then Congress subpoenas Clarence Thomas.
That they won't be able to do, but I do believe they are going to subpoena her.
They're going to try. Are they not going to? Well, if Clarence Thomas has nothing to hide, why doesn't he come and testify in front of Congress?
I think it's just difficult. If you're a current justice ruling on cases, that's a whole different matter. But they can ask her, what did you tell?
Right. But then they try to hold her in contempt of court. And then what do we, it's all in my head, it's all these optics, right? How is this going to look? How is this going to make make everything look. And I know Clarence Thomas is a smart man. I know he's a very smart man, and I know his wife is a very smart woman. It would have optically looked better if Clarence Thomas would have stepped aside and said, I'm a little too close to this issue. I'm not going to disclose why. I'm going to recuse myself from this case. Optically would have looked, I think it would have looked better.
Right.
I don't know if that's true. Everything else, like, it's when you put the court above all else and say, you know what? I don't know how this is going to fail out. I don't know what's going on. I know my wife is into very conservative politics. She's a very big Donald Trump supporter, and I'm grateful we live in a nation where my wife can be politically active and it doesn't affect my career. But I feel that I'll take a step back and let this play out the way it should, because there's still a majority of the Supreme Court that would, they're not going to protect Donald Trump. I mean, they're not going to, the justices I have faith in, Roberts and Gorsuch and even some levels Kavanaugh and Barrett, they're going to protect the nation. They're not going to protect Donald Trump. So I don't think there was going to be some 4-4 split that Clarence Thomas was going to have to be the deal breaker for.
Well, that actually is a good point. He was not the deal breaker in the case as before the Supreme Court.
Right.
In fact, it was an 8-1 decision. 8 justices said, no, you need to, you can't quash a subpoena, turn over the documents.
Right.
Who was the one dissenter? Clarence Thomas. No, it was Clarence Thomas. He actually was the lone dissenter, and I guess that's not a good look. But also, he knew he wasn't the decider. If he had been the deciding vote, then that would have been a whole different issue. And then we probably would have wanted to have known, okay, what did you know? Did you actually know that your wife's emails were a part of these documents you're trying to suppress? I have to think either one, he did not know that, or he's thought, well, I'm not the deciding vote, so it really doesn't matter. I want this opinion out there so it can be recorded as a dissent. Now, this is not the final word or final matter here. There's another case percolating below as to whether or not Donald Trump violated the law regarding this January 6th incident. Did he actually play a pivotal role in inciting it?
Right.
That case very well might end up before the U.S. Supreme Court. And so this whole issue of recusal is going to come back up again at that moment in time.
Yeah.
All right. Moving on now to, I know, a case that you are very interested in. Trevor Bauer v. The Athletic Media Company. This was just filed this last week, and I know both you and I are really excited about this case for many different reasons. Maybe I actually should spell out one of the reasons why we are not excited about the case, but go ahead, lay the factual predicate for this case.
All right. So for those at home, we don't talk about baseball a lot. So I'm going to set who Trevor Bauer is. Trevor Bauer is a pitcher for the Los Angeles Dodgers. Before that, Cincinnati Reds. Before that, our Arizona Diamondbacks. Trevor Bauer was a Cy Young winner in 2021, the 2020-2021 season. Cy Young is the highest award you could get for being a pitcher in the Major League Baseball. He had an amazing season, and he's an amazing pitcher. After his Cy Young award, he was traded to the Los Angeles Dodgers for an insane amount of money. I believe it was a 3-year contract, $208 million with $105 guaranteed.
Wow.
Right? So he won the Cy Young. He went from a $3 million a year pitcher to a $75-ish million or $80 million a year pitcher by winning this award. Trevor Bauer was then in the early part of the 2021-2022 season was accused of sexual misconduct. A couple of women came out and said that Trevor had sexually assaulted them. Okay. They said that they engaged in sexual acts with Trevor Bauer, but he beat them up. He roughed them up a little bit, cracked or fractured their skulls, and decided to sue him for damages now that he's worth $100 million. Okay. Not to say that there was motive behind that. I don't want to put that out there. Just facts is what it is. Right. So Trevor, the one female.
Now hold on, though. I want you to pause right there, because when you said that he fractured her skull, that was one part of the allegations. That's huge. I mean, that's a deal breaker right there. Because before, you're just simply saying they engaged in sex that was rough.
Right.
Oh, okay. Well, then we want more details. Maybe how salacious you want to make this. I don't know, but that's one thing. But when you fracture someone's skull,
that's more than just rough sex.
Exactly. That clearly goes beyond any bounds. So now this guy is guilty. Should never throw another ball in the major leagues.
Correct. So, and again, if you commit a crime, you need to do the time. That's the deal here, especially if you're some hoity-toity baseball player that thinks they can beat up on women because they're a Cy Young winner.
Throw away the key.
Right. So Trevor Bauer did probably the smartest thing that any person could do. He was suspended by the MLB pending investigation, which is the MLB's prerogative. He went dark. He stayed in his house. He stopped and Trevor Bauer is a social media savant. His brand Bauer Outage, the whole 9 yards, is very prevalent on social media, on all of his social media channels. He's always posting. He shut everything down and stayed in his house, made no comments, listened to his attorneys, and just sat there and did nothing. Well, during that time, the online publication called The Athletic, which has become kind of a big media outlet. I would say it rivals almost Sports Illustrated at this point. That's why the New York Times purchased it in late 2021, early 2022. The Athletic and their reporter Molly Knight, quote unquote, received the CT scans, noticed in the CT scans from the victim that Trevor Bauer had indeed fractured her skull, so they ran with the story that Trevor Bauer sexually assaulted this woman.
Okay. Well, and fractured her skull.
So Trevor Bauer is a rapist. He beats women. These are all very detrimental things to a high-profile pitcher in any ball club, but especially the Los Angeles Dodgers.
Right.
So Los Angeles Dodgers canceled his contract for the year. Morality clauses, because it's a business. So Trevor Bauer missed out on $105-ish million, and the female victim, alleged victim, filed a restraining order against Trevor Bauer, which was denied, filed a lawsuit against Trevor Bauer, which was settled for much, much, much less, but not a disclosed amount than what it was for. It didn't even make it to voir dire before settling out of court.
Okay.
And now Trevor Bauer is taking the next step, and he is suing The Athletic and Molly Knight for defamation. So here we are. Defamation, like we talked about in the Sarah Palin case, there has to be a knowing passing of lies that cause damages, and it has to be communicated to a third party.
So the idea is that the Athletic and the reporter, they ran with this story that Trevor Bauer sexually assaulted these women and fractured their skulls, and he is saying they knew better. They actually had the medical documents in their possession. They knew her skull was not fractured. They ran with it anyways. Again, Chris, we got to be careful. We're just very careful. Whenever you comment on these kind of stories, it's difficult because we don't know what actually happened. If there was a sexual assault minus the skull fracturing, you still throw him away like, I don't want him pitching again as a horrible thing. I don't want you playing for my ball club. I don't want to root for you. You can't treat women that way.
Correct.
But we all admit when you throw in there that the skull has been fractured, that takes it to a whole other level of believability. And if that's not true, and they knew it wasn't true, at what point does the media company become liable for damages?
I think it's at that point where they knowingly look at the CT report and see that there's no skull fracture and say, oh, there's a skull fracture. At minimum, they should have got the CT report, the CT scan, and said, I'm not a doctor. I can't answer this question.
Right.
And go to a doctor or a medical expert or even somebody on staff that's done medical whatever and go, show me where the skull fracture's at. And they didn't. They looked at the CT scan, goes, that's a skull fracture, and they put it out and said, look, Trevor Bauer fractured this girl's skull while he was raping her. Neither of which have been proven to be true. And, I mean, that obviously those are huge allegations. Those are ginormous allegations.
And here's the problem. Let's just say you did not run with the skull fracturing part of the story. the story still is an amazing story. That
It
he
is.
sexually assaulted someone, and he's a baseball player worth hundreds of millions of dollars, and probably going to lose his contract.
Right.
Why not just run with that as your story? Why add in the extra part when it's not true? I guess the reporter thinks this makes it a slam dunk story. I don't know, but here's the deal. If you're caught in a lie there, what else are you lying about? It almost
That's
makes
part of it,
all
yeah.
the parts of your story, when you lie about that, it just makes us, it's kind of like the Brian Flores lawsuit. When you engage in overreach and overstatement, in that case, I think some of it was out and out lying, it just makes you doubt all the other parts of your claims that might be valid and true. That's why you got to be so careful, I think, as lawyers and as clients that have lawyers. Don't have your lawyer misstate things or exaggerate things beyond what is a normal, acceptable level of exaggeration. And so, I don't know. Again, we point out this might be different than the Sarah Palin case, because we just came through the Sarah Palin trial where their reporter had an attachment to an email that showed that what they said was not true, but the thought was, well, we didn't read that attachment.
Right.
And so it is a high standard. It is a
really
high
is.
bar. And so
It's
I don't know. Well,
I think that's where it delineates, right? The reporter had plausible deniability to say, I didn't open the attachment. And the court goes, okay, you can't prove that he opened the attachment and that therefore it wasn't malicious. This one, they're like, yeah, we pulled out the CT scan, we looked at it, we saw what we thought was a crack in the skull. It could have just been, I would assume their defense is going to be, she looked at it, she's a lay person, it looked like a crack. But
all right. Well, we will be
we'll
following that case as it's going on and see what happens. It'd be a fascinating case to follow, both from a First Amendment standpoint of what kind
very
of
much so.
rights. At what point are we going to hold media companies liable for their stories that are not true? Then also from a sports standpoint, what's going to happen to these $100 million contracts? Will it be allowed to be just canceled when a person violates their morals clause, especially in these contexts when there might be a lot of area for not believing the person that is making the claims? Next, I want to talk about this, I think, very interesting legal order from a court involving Jerry Seinfeld.
Right.
Now, Jerry Seinfeld is one of my favorite comedians. I've watched every single episode of Seinfeld many times over. I can pretty much tell you every episode from one word or phrase. Chris, are you a Seinfeld fan?
not that level of Seinfeld. I enjoy it when watching it on reruns and when it was live, but I'm not married to the seasons. They're there.
Well, I
They're
want to test you to see.
relevant.
I want to test you and see what kind of Seinfeld fan you are. Let's say you order your soup in not the right way.
soup for
What is
you.
the appropriate response?
No soup for
See,
you.
all right, at least you got that.
You come back
all right.
1 year.
all right. I want to test you a little bit harder now.
Mm-hmm.
Let's say you go to a public restroom and there is no toilet paper. What do you ask the person in the next stall?
No.
I stumped you.
You did.
All right.
Yeah.
That one. All right. So now I know the level of Seinfeld fan you are. You're about let's just say a 2 on a scale of 1 to 100.
Okay, cool.
But nonetheless, the proper response is, can you spare a square? I just had a couple thoughts of asking you a couple of other ones, but I'm just going to stop right there. But nonetheless, let's move on. Jerry Seinfeld was sued because he has this comedy on Netflix called Comedians in Cars Getting Coffee. Now, I have seen this. It is hilarious. I am so envious. He drives around in these cool cars and he picks up other comedians and they just have a conversation.
That's great.
Where they're talking about whatever it is to talk about their comedy routine, about whatever's in the news, and then they drink a nice cup of coffee. All right. He was sued saying that he stole that idea from someone else. Well, his lawyers filed a motion to dismiss in that case, claiming that the plaintiff waited too long to sue.
Okay.
So we're talking about a statute of limitations defense. So right there, lawyer listeners, you know that's not going to take a lot of research, right? I mean, if the case is about you filed it too late, that's pretty easy to defend. Now, you're probably going to do some other work as well. You're going to probably take some discovery as well. But this isn't going to be one of those very difficult cases to argue. I mean, limited briefing is going to be needed on that issue. Oh, you filed it too late. And so that's a pretty simple issue. Nonetheless, Jerry Seinfeld's lawyers, they won the case. So it was dismissed. How much would you pay for that legal representation. So you filed a motion to dismiss the lawsuit because the other side filed it out of time. What do you think the reasonable rate should be for that kind of work?
Okay. Client meeting, reviewing the file, writing the motion, showing up to court. Let's say I'm $1,000 an hour because I'm charging Jerry Seinfeld. I would say somewhere in the realm of like at most 10 grand, 15 grand,
10 grand,
10 grand, 15 grand at most.
I agree. You know what? I can do a Westlaw research. I would have that answer for you in a couple of hours. I might take a week. It's not going to take me any longer than a week to fully brief that case and to file a grand slam winning argument. Hey, they filed this out of time. You might take a couple of depositions. I don't know.
If that.
Here is a problem. Sometimes lawyers get what's called a cash cow of a client.
Indeed.
Like, ooh, we have a client here who is paying the bill. So let's ratchet up our fees. Since we know this is a winning case, let's purposely charge a lot more. So they're going to do the work. Let's just do so much work under this thought of, yeah, we want to make sure every single door is explored, every crook and cranny, and let's just pour all of our time in this case because we got a live one on the hook, right? They know they got Jerry Seinfeld, and also they have the other side. If they win this case, will have to pay the fees. So his lawyers they won the case. They sought $1 million in fees from the plaintiff for filing this lawsuit.
I want to do that.
$1 million.
I want to do that.
That's good work. Well, Judge Nathan dismissed this case and then said that to Jerry Seinfeld's lawyers, no, this is ridiculous. You cannot claim $1 million for a case like this. And so they reduced their fee to $29,000. And so, I don't know, I just found it interesting that a judge would slash the lawyer's fees almost $1 million. I mean, it went from $1 million to $29,000, saying you should not have viewed this as a cash cow and milk this for all it's worth. You got to have some kind of concept of what the actual legal issues are at play and then litigate appropriately. I don't know. Any thoughts on this?
No, oftentimes lawyers go for the most possible money, right? You miss 100% of the shots you don't take. So I'll submit a bill for $1 million, and if I get $1 million, rock on. If I get the actual money I'm owed, then I'll get that. But I think there should be some. I don't know if there should be some ethical rule or something to that. If it's grossly disproportionate, right? If you come in with a bill for $1 million and you only did $30K worth of work, there needs to be some slapping on the wrist to say, stop doing this, because we don't want people to constantly do this. We don't want judges wasting their time ruling on frivolous. I can understand if you did $45K and the judge came back and said, you know what, these 2 depositions you didn't use, you didn't need, we're kicking those out. You're going to reduce the award to $30K, right? I could get that. But when you go $1 million and you're really only owed $30K, come on, man.
Right. Come on.
Get what you should be punished. Like, you should be then required to donate or sanctioned $1 million to the charity of the other party's choosing.
And I think now these lawyers are going to have a hard time going after their client, Jerry Seinfeld, for these fees. If indeed they spent that much time. And I can't do that math in my head on the spot, but you take $1 million divided by $1,000 an hour. That's a lot of time that firm spent on that case. If indeed they did spend that time, could they now really go after their client, Jerry Seinfeld? Surely there's a retainer agreement saying that Jerry's liable to pay these fees. But here's a quick thought for you. No, because you can only bill your client a reasonable amount of fees. And so here in this case, if a judge just said this isn't reasonable, did the judges not simply gut the lawyer's ability to go after their client for recovery of these fees? That very well might be the case.
I totally think that I 100% think that when a judge goes, no, you didn't do this, you're only getting this amount of money, the lawyers can't go back. What are they going to go judge shop? They're going to go.
Exactly.
I know that Judge Burns over in Department 4 said, I don't have a case, but Judge Marone in Department 7 is going to give me the $970,000 that I'm owed.
Moving on now to the Supreme Court in Ramirez v. Collier issued a decision this week. And so this was a case involving Texas was executing this prisoner, and this prisoner wanted his own pastor there in the execution chambers, laying hands on the prisoner and praying for the prisoner while the prisoner was being executed. And that case went before the U.S. Supreme Court over whether or not, under RLUIPA, the Religious Land Use and Institutionalized Persons Act, can Texas tell that prisoner, no, we're not going to allow you to have your minister there and pray for you and lay the hands on the prisoner? Right. Well, under RLUIPA, if there's going to be a conflict between a prison policy and a prisoner's religious beliefs, that prison policy has to pass strict scrutiny, which means there has to be a compelling governmental reason for it, and it has to be Now, policy has to be the least restrictive means of achieving that compelling governmental interest. The court here in an 8-1 decision said, no, this is not the least restrictive means. And so the court said that you can find other ways for Texas, whatever your interests are here in security and maintaining the decorum of the occasion of executing a prisoner, whatever your objectives are, you can achieve those in a way that's not so restrictive on the prisoner's religious beliefs, and
especially their last request before they're executed.
Yes, 8-1 decision. The lone dissenter was Justice Clarence Thomas. So, all right, now let's move over to our courtroom quarterback segment. Now, we're going to start here, Chris, with a very interesting article I found this last week about a Jeopardy question. Do you watch Jeopardy?
I don't.
Okay.
Not since Alex Trebek died. I did watch it for a long time. They're just a lot smarter than me.
Exactly. You're always impressed with how brilliant these people are. But have you ever thought, I wonder how much they actually know about real stuff, like sports? Well, they were asked this question, and I'm going to ask you this question. I'm going to put you on the spot here to see if you can answer it. And then I'll let you know how they answered it. Here's the question for you. Now, obviously, this is the answer. You got to flip it around and give me the question. You know how Jeopardy is done.
Right. What is?
Here is the answer. A few career highlights. He won the Heisman at Auburn, ran for 221 yards in one game for the Raiders, and was an AL All-Star. AL All-Star.
Yeah. Who is Bo Jackson?
Was it that tough?
No. I also was a kid when Bo Jackson was playing for the Royals and the Raiders, and he was like a superhero. That he was a two-sport athlete. He was insane at both sports, and he did that one like perfect catch where he like runs up the wall and robs the home run and comes back down with it. Yeah. Bo Jackson. Yeah.
Exactly. I live in Kansas City, so I was following Bo Jackson that entire time when he was with the Memphis Chicks and came back up. We called him up to, watch him hit those home runs. He was in the All-Star game, hit a home run to lead it off. An amazing athlete. I think he's probably the greatest athlete of our time. I mean, what other player can you name that was at the highest of his sport in two different sports? Right. I mean, he was the best running back in the NFL and then probably one of the best outfielders in Major League Baseball. I can't think of anyone else at the top of two different sports at the same time. Well, these three Jeopardy contestants, they were caught looking. No one even hit their buzzer to offer up a guess. And so, hey, you have one now on the Jeopardy contestants. All right, moving on now to what else is going on in the world of sports. Bruce Arians retired this morning. Kind of shocked a lot of people.
Right.
And did you catch his replacement? I believe he's being replaced by Coach Tom Brady. So not a bad call there.
Tom Brady is stepping into the coaching position. Well, I also have to think, and I think a lot of us are out here speculating that was part of Brady's return, was that Arians would move on. Because they didn't get along. Now, this hurts me deep because this squashes any thoughts of Tom Brady going to San Francisco.
Now that you had the first player coach in
NFL history,
several years at the NFL, you probably go back in the 40s and 50s.
Right.
Maybe there might have been one. I don't know.
Right.
But yeah. Now, Todd, the actual, I was just kidding. The
Todd
actual
Bowles.
coach who's replacing Bruce Arians is Todd Bowles, who was a defensive coordinator at Tampa. More on him in just a bit. But he's not going to know much about the offense. So clearly, this is going to be Tom Brady's offense to run. We might see a real, player coach here in the NFL.
But why? I mean, it's Tom Brady. All right, I'd be worried about like Tua or Burrow or Trevor Lawrence being player coaches. It's Tom Brady. He's the elder statesman of the sport at this point. Right. Well, I was reading the other day that between Tom Brady's Super Bowl wins, between his first Super Bowl win and his last Super Bowl win, Troy Polamalu was drafted, played, and was inducted into the Pro Football Hall of Fame.
Wow.
So Brady's been there for a minute.
Wow. He's probably older than most of the NFL coaches out there.
Right.
Well,
definitely older
Todd
than
Bowles?
the last two Super Bowl coaches.
Yeah, right. Well, Todd Bowles was the former head coach of the New York Jets. He was 24-40, and I believe for some seasons there at the New York Jets head coach. So my thought is, if you went 24-40 as the New York Jets head coach, you probably are a Hall of Fame head coach. And so he probably is a really good coach if he was able to win 24 games for the lowly Jets.
Yep.
But I guess more on that later. But yeah, that's an interesting development. Also, this last week, the NFL changed its overtime rules for the postseason. Now, Chris, I don't know. I'm having a hard time with this with these articles, because when I read this in the articles, most of these articles were written like this. They were saying, look, because of what happened this last year in the Buffalo-Kansas City Chiefs game, where the Chiefs got the ball first in overtime, they scored a touchdown. Buffalo never got the ball. That was just a grave injustice, and we got to fix that inherent unequalness, that the grave injustice that occurred during that game. Is that the kind of the tenor of the articles you read?
Yeah. And don't get me wrong, that game was amazing. That game was that instant classic, right? Instant classic game.
Right, it was.
But yeah, that's the thing. People wanted more of that game. And I think that's more of a commentary on how bad football's been versus how bad the rules of overtime are.
But I want to call BS on that, because 3 years earlier,
Chiefs,
the same context, AFC Championship game, the Chiefs played the Patriots. We went to overtime. We lost the coin toss. The Patriots got it. They scored a TD.
Game
we
over.
never touched the ball. Where was the outcry then?
Yes.
But the Chiefs did suggest a rule change to the owners. The owner unanimously rejected it. Like, no, it's not about fairness.
Right.
It must be about some kind of anti-Casey bias. I don't know, but I do like this rule change. But don't say it's because you want fairness. If you wanted fairness, it would have been done 3 years ago when it happened against the Chiefs and not for the Chiefs as it happened this time.
Right.
Do you like the new rule? So the new rule is both teams get to possess the ball in overtime. Is that your understanding?
Yes.
I don't like this rule.
Nah, I
can tell you.
Why don't you like it? Why? Hit me.
Here's why. Here's what's going to happen. Let's just say the exact same scenario happened, what just happened with the Chiefs. The Chiefs are going to get the ball. They're going to score a touchdown. Buffalo's going to get the ball. They're going to score a touchdown. Chiefs are going to get the ball. They're going to kick a field goal, and everyone's going to complain. Hey, Buffalo did not get to touch the ball twice.
Right.
This isn't fair. We should allow both teams to touch the ball twice. Is that where this is going? Where both teams are going to get equal touches during the overtime?
I don't know. It might, depending on how it rolls out. I think that I have problems with the NFL on a multitude of reasons, trying to overcompensate for the fact that they want to somehow make more money at the end of the day.
Right.
They didn't see the rule change when it was Kansas City because it didn't matter to them. The Patriots are the big draw. Now that the Bills and the Chiefs and everybody had a great game, now it's like, oh, we need to evaluate, we need to change because we can make more money. And at the end of the day, that's what they're looking at. So they could in 5 years could come back and go, this really screwed, Tom Brady. So we need to come back and figure out how we could change these rules. So that way the Buccaneers would have gotten, 16 possessions to match the 15 possessions of the Kansas City Chiefs.
Right.
Right. I don't put that past Roger Goodell. I really don't.
I think you hit the nail on the head right there. It's the postseason. It's the NFL. All eyes are watching the NFL playoffs. Right. And if you are in overtime, everyone is really watching. Ratings. So why not find a way to extend that game?
Well, yeah. And then the Bills-Chiefs rivalry now is going to be insane, right? The Bills Mafia, Chiefs fans. The Chiefs donated to a Bills charity. The Bills were donating. They see the good in this rivalry, and rivalries make money. U of A, Arizona State. We are in football. We're going nowhere. Both teams. But that rivalry game is sold out for weeks. Merch is bought for weeks. Food is jacked up. Restaurants, hotels, everything. Rivalries sell. So I think they're going to keep riding that wave.
Well, there you go. I'll let you have the last word in this week's podcast. March Madness is right around the corner. You're on your way to New Orleans to enjoy the greatest morsel of food ever at Drago's. And then you're going to go over and get a nice beignet there at the Cafe Du Monde. I am so jealous. If you can get tickets to the Final Four, wow, what a weekend that will be. But hey, go say hi to Bill Self for me and have a great week.
See you, Joel.
Thank you for listening to today's podcast. If you enjoyed this podcast, please give us a 5-star review. We need your love to help us continue highlighting the funnier side of the law. I want to give a special shout out to our Vice President of Operations, Wendy Oster, without whom this entire operation would be a complete and utter mess. Sean Wynn and 15-5 Features for making me sound way better than I actually do. Brooke Boland for our marketing efforts, and Ryan Kuhn and Paul Kuhn of Triplicity Marketing for our technical and computer support.